Thank you, sir. All right, ladies and gentlemen, we are going to... Okay, two people want to talk about your comments. Mr. Williams from the San Luis and Delta Medota Water Authority and Westlands, Ms. Terry from the North Delta Water Agency. Briefly, please. Mr. Williams.
Okay. Hi, Melinda Terry, North Delta Water Agency.
Terry, I'm sorry.
Yeah, I wasn't around, obviously, when our contract was negotiated. It happened over decades. It was eventually signed in 1981 and really was called for in the legislation on the original peripheral canal. That was one of the things they wanted them to do, these contracts with the local delta. I think there's 15 entities that were named in it, and we were one. And on Randy's question, I thought it kind of related to that, which was originally they apparently had the delta as part of the whole settlement contract for the north of the Delta too, but when they realized just how different it is because of the tidal, that it's occurring, and because we have a shallow groundwater that's coming up, all the time, that they said, no, let's separate you out, and that's when they created the agencies for the Delta, if you will, for the purpose of negotiating those settlement contracts, which we in fact did, and then as part of our contract, it says that the folks in the North Delta have the right then to divert the water. But it is limited, like you said, to, it has to be reasonably beneficially used. And for us, it has to be used within our agency. So it would really require, I think, both DWR and the agency. So we don't do transfers, for instance, because it would require something extra. It's supposed to be used within the Delta and then reused possibly by someone else. Thanks.
Okay. Thank you.
Just briefly, if I could just briefly
respond
on I did mention the North Delta contract real briefly in a footnote because not all water service contracts are created equal. There are some water service contracts that do certainly provide a priority to area of origin type people based on their senior water rights. There were various settlement and exchange contracts that were entered into in the early days as the projects were being developed and as people were protesting some of the water rights for the projects. And in a similar vein, that the North Delta Agency contract certainly provides some priority to users in that area.
Okay, thank you. Mr. Williams.
Thank you, Mr. Chair, members of the Council. My name is Philip A. Williams. I represent San Luis Delta Mendota Water Authority in the Westlands Water District. You just got a great presentation from Mr. Wilson, and I am following him again. He's going to be sick of me, I'm sure, soon.
Is this a repeat of the Water Board presentation?
Yes, sir. Okay. The Water Master's report does an excellent job of presenting and packaging the California area of origin laws and presenting it in a format that's approachable to the layperson. However, we feel that raises a couple specific concerns. First, that it misstates the law as to the watershed protection statute. And second, that it mischaracterizes some other portions of law from cases that Mr. Wilson just talked to you about. To our first point, our first concern, the Water Master's report states that it fails to acknowledge that on page 9, his report states that the watershed protection statute makes it clear that the Water Code section 11128 makes it clear that the watershed protection statute applies to the federal government and therefore the Bureau of Reclamation. That's on page 9 of his report. Okay. What his report does not state is that section 11128 actually cites specifically to two provisions in the watershed protection statute, sections 11460 and 11463. This is important because essentially the underlying theme is that it does not allow rights to accrue against the Bureau of Reclamation. Specifically, section 11462 does not apply to the Bureau of Reclamation. The legislative history, and Mr. Wilson referenced a couple AG opinions as well in his report, but didn't fold in the analysis of those AG opinions. We feel that analysis is actually extraordinarily helpful. I personally found them very helpful. Because what it does is outlines not only the history of the watershed protection statute, but the legislative history behind section 1128, which specifically says that only two sections apply to the federal government and the Bureau. It also goes into how that ties in the interaction with section 8 of the Reclamation Act and the complex interaction between state law, state water right law in California, and the authority of the Secretary in and distributing water rights through the Central Valley Project in accordance with state water law. To the extent that his report fails to specify that only 2 sections of the Watershed Protection Statute apply to the Bureau, we feel it's a misstatement of the law. To our second point, our second concern, we feel like his report, again, citing to those cases, characterizes the law. Mr. Wilson referenced you to Justice Roby, his opinion in State Water Resources Control Board cases, and also when he was sitting on the Ninth Circuit for the Tehama-Colusa Canal Authority case. The report on page 10 cites the State Water Resources Control Board cases and states that the State Water Board cannot reduce an area of origin user's contractual allotment of water in order to supply water for use outside the area of origin, absent some other legal basis for doing so that trumps the statute. His report characterizes this as law, when it was not a holding central to that case. And not only that, later in Tehama-Colusa Canal, the Ninth Circuit went back and affirmed, again, did not overrule or didn't overrule what Justice Roby had said in State Water Resources Control Board cases, but emphasized that's dicta, that isn't actually a holding that's central or a rule of law that was central to that case. To the extent that his report characterizes that statement as law, we feel it's a mischaracterization. It's more properly understood as dicta, and therefore wouldn't be controlling. Secondly, the report makes the opposite mistake in El Dorado. Mr. Wilson actually just spoke to this point. The statement on page 11 says, after a brief discussion of the county of origin laws, we feel that the way that this is presented to the layperson makes it sound as if it's dicta, that the conversation that the court had in El Dorado about the county of origin isn't central, when in fact what the court was doing at the time was overruling a lower court's point on this exact point. So to the extent that that statement makes it sound like that ruling is dicta, we would disagree and argue that it's a mischaracterization. That's actually central to the holding. Subject to your question, sir, or members of the council. That's all I have.
May I reasonably conclude that your interpretation of Mr. Wilson's memo might be more favorably beneficial to your clients than not?
Our characterization is more appropriate to how the law actually reads.
Got it. Got it. Thank you, Mr. Williams. Appreciate it.